Hello everyone. Happy early Easter. Oh, let me turn my phone off. I always do that. Happy early Easter. I have something super cute to share with you before I get started. So there is one of my little babies, and he's dressed up as the Easter bunny. It's one of my lizards. He's a white one, so I thought it was fitting. I have a couple of them in Easter stuff, but that one's my favorite. Let me get this off. So, today I'm gonna go over Morphew a little bit. I'm gonna just give a short little recap in case people come in that don't know about it, like super short. And then I'm gonna go through a bunch of motions that I have and things like that. So, let me put this up again. It's my little Easter guy. And let me remove this real quick. So, to give a little recap, I'll just do that real quick. Suzanne Morphew. Hey, Lexus. You driving right now? Are you listening while you're driving? Hopefully I keep you company. So Suzanne went missing on Mother's Day, May 10th. She supposedly went on a bike ride and never returned. Her daughters couldn't get a hold of her, so they called their dad, who was away on a job on a Sunday on Mother's Day. Sorry, my allergies are bothering me a little bit. He'll probably just be bothering me for the next couple months, so just expect it. But and my neighbor's outside doing some work, so if you hear any background noise, that's what it is. But anyway, they called their neighbor, who then went to the house to check if she was there, and she wasn't there. So they reported her missing. The husband, Barry, was in Broomfield. I think it's like 130 miles away or so, doing a job. He ends up getting arrested for her murder, and some things come out that they believed that he killed her on the 9th. They believed he used a tranquilizer dart to subdue her, and I guess leave without, like, that's how there was literally no evidence, no body, no blood. I mean, no physical evidence whatsoever. So I guess they theorized that he tranquilized her and then killed her after they left the house. So that's why they have no body or blood or whatever. And then 6 months into the investigation, they find a spy pen in a box in her closet that reveals she was having an affair for 2 years with a man that she hooked up with in high school, Jeff Libler, who was married with children. He, when she went missing, he didn't come forward. He was pretty just silent. His phone got destroyed. This is a little odd. He said that he didn't want that to be like her legacy, so that's why he didn't come forward. And there's just been people think that Barry could have been involved because of some weird things with his phone pings, with his truck telematics. He made several trash dumps on the way to the hotel in Broomfield on the way to do the job. Just, things that seem suspicious. But at the same time, some of those things could possibly be explained away. Like, Barry was a contractor, so trash dump contractors, even though it's not very ethical, a lot of contractors do it, especially on Sundays or holidays when you have a truck full of stuff and the places are open, and you go dump in a couple dumpsters so it's not too noticeable and you don't get reported. His hotel room supposedly smelled like chlorine, but his hotel room was right over the pool. The pigs around the house supposedly wouldn't make sense if he was moved. Like if all those pigs were right, he would have had to be moving at like 40 miles an hour and going through walls. There's also something called static drip, which could make, like in a small area, all the satellites trying to pick up on the phone could create it to look like that. And then, what was the other stuff? The truck telematics. There's some things that seem like they might be a little wonky, stuff like that. So it's really one of those cases where it's very circumstantial. No direct evidence, no physical evidence, but just a lot of circumstantial evidence. So they go to court, setting up for this trial. At the preliminary hearing, a lot of the stuff comes out, and then the defense accuses the prosecution of withholding exculpatory information because there was unknown male DNA found in Suzanne's car. The unknown male DNA, it was a partial match. They ran it through CODIS, and it hit on 3 cases. They further investigated the cases, and they were ruled out, which I do have some information on, which I will go over that today. And also, they accuse them of actually a lot of stuff. One of the lead investigators, they didn't like the way he testified, so he got thrown off the case, and then he got sent to the marijuana unit. Then later down the line, he ends up shooting himself in the hand and gets investigated by Internal Affairs. And he tells Internal Affairs that CBI made the stupidest decision they had ever made by arresting Barry Morphew, and that it was too early. CBI, most of the people from CBI were subpoenaed, and they testified that they all agreed that the arrest was too early and that they tried to beg Sheriff Speasy not to arrest Barry, but they did anyway. And then, so now, where I left off, I guess, was the Judge Lama. They filed a motion to dismiss based on the exculpatory evidence and discovery violations, which the prosecution has been very late to hand a lot of things in, and they keep receiving discovery violations for it. They had a bunch of expert witnesses that they wanted to testify, and they had until February 7th to hand in all the information for them, and they weren't ready by February 7th, so they asked for a continuance, and they got a continuance until February 28th. Now, they handed all the information in for the witnesses, except for their CVs, which is a curriculum vitae. I think that's how you say it. I could be saying it totally wrong. But basically, what a curriculum vitae is like a resume for an expert witness. Give me 1 second. Sorry. A curriculum vitae is a resume for expert witnesses. So it's basically something for the judge to look at and see the credentials of a person. So that's how they can tell that they are an expert witness. So basically, they handed everything in but that, which I think is pretty important because that's what separates a regular witness to an expert witness. So they weren't on time, and they've received some discovery violations for that. And because of that, a couple of their expert witnesses they weren't allowed to have them as expert witnesses anymore. They have to use them as lay witnesses. Now, there's a big difference between expert witnesses and lay witnesses, and I'm going to try to explain this the best I can. So, an expert witness is somebody, well, actually, let me start with a lay witness because it's a little easier. So, a lay witness is somebody who could testify as to what they saw with their own eyes. So, imagine you witnessed a car accident and you're testifying. You can say, oh, I saw the car. It was blue. It was going so many miles per hour. Or it seemed like it was going so many miles per hour. Like, that's what it looked like to me. The person looked like this. They were this tall. They were this far away from the curb. Whatever. So it's basically lay witnesses can only testify as to things they observed with their own eyes. They are not allowed to testify anything scientific or technical. So this is where it gets really tricky. Like, expert witnesses an expert witness could talk about the mechanics of the car and maybe why the brakes failed in the car and how the car works and things like that. So basically, they're expert witnesses. They had one that was for the truck telematics, one that was to explain the unknown male DNA in Suzanne's car and how it was a partial match, and how it's very unlikely, or how the partial match couldn't have been it's hard to explain, but basically this DNA person was going to explain away the unknown partial match in DNA terms. And then there was a telephone expert to explain the pigs and stuff like that. He's also not allowed to testify. And there was a dog handler who he's not allowed to testify because they handed in his stuff, but they didn't hand in report in, and the defense said that they never received this report. And then the prosecution said, well, we had no idea there was even a report. So the judge asked the guy, like, hey, did you write a report? And he said, yeah. And he's like, well, why didn't you give it to him? And the guy said, well, they never asked for it. So they were like, that's a discovery violation because that's your job to get that report from that guy. It's, your job as the prosecution. So the prosecution said, well, we don't want that guy to testify anymore. And then the judge said, well, I still want to hear what he has to say. So he went up on stand, and here, one of the deputies who was there at the time that the scent dog was there, he wrote a report himself based on what he observed. And they went over his report along with the guy who actually did the scent stuff, and the guy who had the dog scent, basically his version of it didn't coincide with the other version of it. So the dog picked up a scent and followed it all the way down to the river, but the deputy basically wrote his report that the dog didn't pick up a scent. So he's not testifying, but now he might be testifying for the defense. So that will be interesting. And then there was a veterinarian who was going to testify about the tranquilizer darts. And she's not anymore because she's not as an expert. She can as a lay witness. but she's not anymore because there is no what's it called, studies done on how it affects humans, or like how, so there's no studies done on how this dart could affect like differently, how it affects animals or humans differently, or if it affects them the same. She's only an expert in the animals, not humans. There's no toxicology report from Suzanne, so obviously they have no idea if Suzanne had any tranquilizer in her system. So the judge said it was too speculative, and it's like saying, oh, well, since there was a knife in the kitchen, she must have been killed with a knife. So that's out. There's a few that are still up in the air. There's a nurse who is going to look at pictures of Barry's arm and say if they're nail marks or not. I don't know if she's going to testify or not. They're going to decide that on the 29th. The defense is saying that she shouldn't because she might be an expert on cuts, but she's not an expert at looking at cuts in photographs and making that determination. So they have a Shrek hearing on the 29th, the day after they pick the jury, and they're going to decide that. Hey, Queen Bee! And then, let me think. There's so much. So 14 out of their 16 expert witnesses can only testify as lay witnesses, which sucks for them because, they're very limited on what they could testify about. So, in response, sorry, I kicked myself out. Is everyone still here? I don't know how I did that. I don't even know what I did, but I hit a button and I ended up getting out. Oh, sorry. Anyway, so in response to the judge's decision, he basically said, listen, guys, I'm not going to dismiss the case, but this is just how it is with the witnesses. He pretty much said in a nutshell that the prosecution had made a lot of discovery violations and that they were borderline reckless, and it was pretty tough on them, I'd have to say. So then, let me see here. This one is this one. Okay, so Linda Stanley. Let me share my screen. Okay. So Linda Stanley responds, and I'm not going to read this whole thing, but I'm going to put it in a nutshell for you. Based on the assertions of defense counsel, the court ordered that several of the people's endorsed expert witnesses will not be allowed to testify as experts at the defendant's upcoming trial, namely Megan Doog. Now, Megan Douge, maybe? She's the one. Let me put this up. She's the one who was going to explain the DNA. Ken Hicks. I think he might be the telematic guy. Kevin Hoyland is the phone ping guy. Andrew McDermott, James Stevens, and law enforcement officers Derek Graham, Johnny Grusing, Ken Harris, Andy Rorick, and Alex Walker. However, following the court's order, the people reviewed the discovery disclosed in the case to determine that the people disclosed all necessary materials associated with Megan Doog well before the deadline imposed by the CMO in the case. So Linda's saying, oh, we know we did hand this stuff in. The only thing we didn't hand in was the curriculum vitae. Now, if anyone who came in here that wasn't in here when I explained this, a curriculum vitae is pretty much like a resume for expert witnesses, and it's what the judge looks at to determine if, like, if they're experts. Like, he looks at their resume and says, okay, this person's an expert based on their work history. So she's claiming she handed all the stuff in by the deadline, just not that. But I think that's pretty important because that's what differentiates a lay witness from an expert witness. Discovered on March 1st, a day after the court's deadline, all materials associated with Ken Hicks, Ken Hicks was given with the exception of their curriculum vitae. Discovered on March 1st, a day after the court's deadline, all other materials associated with Ken Hicks, Kevin Hoyland, James Stevens were also discovered to defendant well ahead of the deadline. These experts and their testimony are critical to the people's case. While most materials associated with the above-named law enforcement experts were also timely discovered, the people are not requesting any relief with regard to the court's order as it pertains to these witnesses or Mr. McDermott, who has yet to complete an expert report in the case. So basically they're saying, like, we don't want relief for all the experts, but we do want Miss Doog, Mr. Hicks, Mr. Hoyland, and Mr. Stevens. So the defendant is, as the people have complied with or substantially complied with, substantially complied. The expert discovery deadlines for Miss Doog, Mr. Hicks, Mr. Hoyland, and Mr. Stevens, and the defendant is not prejudiced by the people's single-day delay in providing CVs for Mr. Hicks, Mr. Hoyland, and Mr. Stevens. The people request that the court partially reconsider the order and allow the expert testimony for Megan Doog, Ken Hicks, Kevin Hoyland, and James Stevens at trial. Now, here's the problem. They had a February 7th deadline, and then they had an extension to the 28th, and then they still missed that deadline for the CVs. So, like, they had extra time, and they still didn't get it all in. So then they give a little background of Barry, and that the case against the defendant relies heavily on several key pieces of evidence, namely his motive to harm his wife, the opportunity he alone had, as he was the last person to see her alive, the inconsistencies in his statements to law enforcement, and the ultimate cover-up he perpetrated the day after and in the following months. Testimony from several of the named expert witnesses, but particularly Ken Hicks, James Stevens, and Kevin Hoyland, are critical in establishing the above facts. So Ken Hicks is the expert in telematics. Ken Hicks downloaded the defendant's truck information for the days surrounding Miss Morphew's disappearance and subsequently authored a report that outlined his findings. See Exhibit 1A. The truck data, or telematics, shows all the activity associated with various vehicle function, including the opening and closing of doors, turning on of cabin lights, the opening and closing of the truck bed, when and how long the truck was turned on, the speed the truck was moving when traveling, and ultimately exact GPS coordinates when the truck was moved between locations. Mr. Hicks' testimony is critical to disprove several of the defendant's assertions. First, the truck data disputes the defendant's initial alibi that he went to bed early on May 9th of 2020, the night before Mr. Morphew was officially reported missing. The night before Mr. I think they meant to put Mrs. Morphew, but the data shows him apparently loading his truck over several hours late into the evening. Further, it shows the defendant's truck was at all times at the home that evening, except for when the truck was briefly moved just before 10 p.m. from near the house to the front, where the driveway enters the main property, seemingly blocking in cars from going in or out. Next, it shows the exact locations the defendant was tracked to the next day, leading law enforcement to the collection of video surveillance showing 5 separate trash dumps once he reached Broomfield. So him being an expert witness is important because if he's not, he won't be able to explain the truck telematics because the truck telematics is technical. It's technical and scientific. It's not just something you observe with your eyes. So that would really hurt their case and put them in a major bind. James Stevens, he's the forensic computer data analyst. James Stevens downloaded several phones in the case, but specifically extracted data from the defendant's phone, which was determined through investigation to be a white and gold Apple iPhone SE. The extracted data was put into a user-friendly format, then placed on thumb drives and turned over to investigators on the case. Based on his extractions, it's okay, Gladys. Better late than never, right? I'm not too far into it, so you didn't miss a lot. I'm basically going over Linda Stanley begging the judge to allow a couple of the expert. So the judge basically told them that 14 out of 16 expert witnesses couldn't testify as expert, and they can only testify as lay witnesses, which is very bad for them because lay witnesses can only talk about what they see with their own eyes, and expert witnesses can explain scientific and technical data, which, telematics and phone data is scientific and telematic. Without these experts, they won't be able to explain any of that data. So, based on Mr. Stevens' extraction, several pieces of incriminating evidence were found on the defendant's phone. Specifically, Mr. Stevens will testify that the data was deleted in bulk before the phone was seized. Notably, 381 text messages, 25 calls, and 58 saved locations. Some messages were recovered, however, to include a May 6, 2020 text sent from Suzanne. Morphew to the defendant that says, "I'm done. I could care less what you're up to or have been for years. We just need to figure this out civilly." The text goes directly to motive in this case and rebuts the defendant's continuous claims after his wife went missing that their relationship was without problems. So Kevin Hoyland, he's an expert in cell phone tracking and historical call data analysis. He authored a report comparing several pieces of extracted data from physical items and information obtained by search warrant. Specifically used data collected from Suzanne's phone and compared it to information extracted from the defendant's truck, Bobcat, and phone to determine a timeline of events. I need to take a sip of my drink real quick. 1 second. Sorry. The report also uses the previously extracted phone data from the defendant's phone to show a pattern of airplane mode around the most influential times in the case. This timeline is critical to the people's case as it disproves many of the defendant's assertion about what transpired surrounding his wife's disappearance. All right, Megan Douge, she is the CODIS DNA expert. So she provided information related to potential CODIS matches discovered in a DNA mixture developed from the glove box area inside the victim's Range Rover. Her testimony rebuts a likely defense theory that the DNA from the glove box relates to some unknown violent sex offender from out of state. Although brief, Ms. Douge's testimony will explain that these comparisons are based on limited genetic information. The defendant has been in receipt of the expert opinion reports associated with Ken Hicks, James Stevens, Kevin Hoyland for many months in advance of the original disclosure deadline. So this chart shows the discovery that they gave to the defense, which we know they gave the stuff to the defense, but they didn't hand in the curriculum vitae, which I don't think the judge cares at this point what it was exactly. I just think that he's a little upset that they've been late with a lot of things. Thus, with the exception of the CVs for Mr. Hicks, Mr. Hoyland, and Mr. Stevens, all materials associated with these experts were disclosed well ahead of the court's February 14, 28, 2022 deadline. Ken Hicks is the only witness in this case who prepared a telematics report from data extracted from the defendant's F-350 truck. The report is 10 pages long and not at all complicated as far as expert reports go. Mr. Hicks extracts the underlying truck data and places that data into specific action events with associated times. Action events include the opening and closing of doors, turning the engine on, and vehicle movements. The telematics also show the GPS location for the truck during these events, allowing the comparison of events and location. Taken together, the truck telematics help establish a timeline that is later used to confront the defendant on his recollection of events, given he was the last person to see Suzanne Morphew alive. The defense specifically claims that this is a law enforcement report, which suggests this is a lay witness, but there are no expert opinion reports. If this is the case, the contents of Mr. Hicks' report would be admissible at trial, and his apparent lay opinions would not be excluded by the court order. And then they're saying that earlier, I guess the defense said that it was a lay witness report. But now, after they excluded this guy, now they're saying that he's a witness that has specialized knowledge and experience. It's pretty much the same thing. They're just going over, like, at the preliminary hearing, they talked about certain things so they know what he was going to talk about. And then James Stevens is the only witness in this case that extracted the defendant's cell phone. That his notes regarding his extractions and methods he used are described in a larger document that was provided to the defense last summer. I mean, they definitely had all this stuff, but it still, I think, the only one that he might allow is Megan Douche because they were late with all these CVs, which it's still late handing material over. Kevin Hoyland authored a report comparing several pieces of extracted data from physical items and information obtained by a search warrant. Mr. Hoyland is the only endorsed prosecution witness who looked at call detail records from the defendant's phone and cross-referenced the GPS data provided by the telematics to provide a timeline of the days surrounding the victim's disappearance. So they're saying that the defense is saying that they didn't get any expert report from him at all, and the prosecution is saying, yeah, they did get an expert report. It's just labeled as a draft, but since it's labeled as a draft, it's not considered a report. It's considered a draft. So I don't know if it counts or not, but so this is more of them showing where they put the discovery. So Douche from CVI will testify to the CODIS hits discovered in the victim's Range Rover and the strength of those leads. A layperson would not have knowledge of how CODIS works or what a potential match looks like. This will be mostly critical to refute the defense's likely claim that the... Why is this weird like that? Okay. The defense's likely claim that the unidentified DNA in the car was actually matched to someone as opposed to a mere investigative lead. The defense is in possession of the only report Miss Douge authored in this case, which will be bound to come trial. They just showed them, now they're showing an example of them talking at the preliminary hearing about Megan Douge. Hold on. Trying to find, just break it down so I don't have to read the whole thing. So they're saying they have no discovery violations related to Miss Douche, so they would still like her to testify. And everyone else is a 1-day delay in disclosure. In the event that a discovery violation is found, the decision to impose a sanction is within the sound discretion of the trial court. Among the factors the court should consider in fashioning an appropriate sanction are the reason for the delay in providing the requisite discovery, or 2, any prejudice party has suffered as a result of the delay. 3, the feasibility of curing such prejudice by way of continuance or recess in situations where the jury has been sworn and the trial has begun. The ultimate purpose of discovery sanctions, like the discovery process itself, is to advance the search for truth. Pretty lame of the prosecution. If they only had to turn in what amounts to resume, they should only be forwarding files, right? No, that's exactly their a curriculum vitae is pretty much just like a resume of the expert that shows that it's an expert, like of all things that they handed in on time, way ahead of time. And then they had 2 weeks to come up with these resumes and they didn't get them in on time. I mean, come on. Like, I just feel like they're majorly dropping the ball. Sorry. When I start reading, my mouth gets a little dry. Any discovery violation related to materials associated with Mr. Hicks, Mr. Hoyland, and Mr. Stevens is de minimis. First and most importantly, all material related to the substance of what Mr. Hicks, Mr. Hoyland, and Mr. Stevens will testify to is provided to the defendant well ahead of the February 14th, 28th expert discovery deadline. The only material provided 1 day late was each witness's curriculum vitae. As noted by the people at the March 10th, 2022 hearing, the failure to provide the CVs of Mr. Hicks, Mr. Hoyland, and Mr. Stevens was inadvertent. The people fully believe defendant received the CVs on February 28th, 2022. The failure to provide these documents to defendant until March 1st was merely an oversight. Alright, so this is where she kind of explains how bad this could be. Generally, sanctions as severe as dismissing a case or excluding witnesses only occur when discovery violations are an issue during trial, not almost 2 months before trial, as is the case here. But the case here is that there's been a lot of discovery violations from day one. Like, they've missed lots of deadlines and haven't handed over things for months, so I just don't think it's... I feel like the judge is trying to be fair and they just keep screwing it up. So now they're just citing some cases. Dismissal is occasionally necessary to prevent an unfair trial, even if such a severe sanction might be appropriate in some cases of willful misconduct. Now, the judge said he didn't find any willful misconduct, but that he was going to base his future rulings on that motion, and that if they kept doing it, he may find it willful. It is certainly beyond the discretion of the trial court where the conduct was unintentional. Several examples of appellate review provide further guidance. Where the court found that the discovery violations were inadvertent rather than willful, the trial court has abused its discretion in granting dismissal. Where the prosecution had not disclosed the videotaped interview. Oh, they're citing some cases again. Alright, here's where they pretty much say the big things. The exclusion of these witnesses damages the people's case in a profound way. In a no-body homicide case such as this, the timing surrounding the victim's disappearance is everything. The defendant admits he is the last person to see Suzanne Morphew alive, and thus his credibility is the central question the jury must resolve. By excluding the most damaging impeachment information against this defendant, cell phone data, truck telematics, and GPS CDR locations, the court has imposed sanctions tantamount to dismissal, with the defendant suffering a complete windfall. Basically saying, like, I don't know why they said defendant suffering a complete windfall, because it would be the defendant being super lucky. The Honorable Patrick Murphy found a discovery violation on July 22, 2021, but did not find any willful misconduct on the part of the district attorney's office. It ultimately found that the issues were remedied even before the preliminary hearing. See transcript July 22, 2021, pages 52 to 53. In this court's ruling for March 10, 2022, there was again a finding that the brief delay in CVs was not willful, but there was a pattern of neglect from this case. See transcript March 10th, 2022, 164 to 165. This pattern was based on Judge Murphy's initial finding of a discovery violation combined with the court's second finding for late CVs from some experts at the February 28, 2022 deadline. The court's basis for sanction was derived from perceived prejudice the defense suffered in not knowing what the people's experts would testify to. This motion for reconsideration aims to clear up the factual record and in turn shows the defense assertions that the court relied on to be false or completely exaggerated. As a subsequent issue, the court also found an additional Rule 16 violation at the hearing on March 30th, 2021, but again found the violation was not willful and striking the individual witness was sufficient as a sanction. Oh yeah, that was the other violation with the dog. They didn't ask the guy for a report, which kind of makes me wonder, like, did they purposely not ask that guy for a report so they could write their own, and then when they found out that they wanted the report from him, they didn't want him to testify anymore, but the judge said, hey, I want to hear from you anyway. And then he went up and told his story, and his report was far different from the one they wrote. Like, what they wrote was completely different than what he said happened. So, I don't know. I just thought that was a little bit weird. Oh, sorry. Okay. It said that people request that the court reconsider its order. Oh, wait, sorry. The people have heard the court's concerns regarding compliance with the CMO and understand the court and defendant's frustrations. In total, the court has stricken 12 out of 14 of the people's proposed expert witnesses, and yet the people are not asking the court to reconsider the order from March 10th, 2022 in its entirety. Said the people request that the court reconsider its order with regard to Ms. Douche, Mr. Hicks, Mr. Hoyland, and Mr. Stevens. So they only want those 4 witnesses because those ones are the main important ones, I guess you could say. And then, so this is basically the defense striking back. Um, so this is the defense saying that they request the court to deny the prosecution's motion for reconsideration. These stricken excluded witnesses do nothing to prove that Mr. Morphew is guilty of murder. There is no evidence of murder, and certainly no evidence that Mr. Morphew committed a murder. It has been well established and confessed by the prosecution that there is no body, no confession, no eyewitness testimony, or physical evidence that Miss Morphew is dead, was murdered, or that Mr. Morphew is responsible. The facts in this case are insufficient to reach a murder conviction, and stricken experts do nothing more than bolster uncorroborated theories and hunches the prosecution would like the jury to adopt in what would be a specious and wrongful conviction. I think that's how I say it. Over and over again in open court, the prosecution continues to claim that the defense has all the discovery, including expert reports. In fact, they have claimed they have bent over backwards to provide it. The court knows this is not accurate. On March 10th, the court gave the prosecution a third opportunity to present the prosecution's expert summaries or reports in compliance with the October 13th, 2021 verbal order and October 29th, 2021 written case management order to this court. Now, 6 weeks after the prosecution expert disclosures were ordered, due and 3 weeks after the court struck these witnesses, the prosecution reports to provide the information to this court, including providing new information and reports that it claims are critical to prove its theory of murder. However, even 6 weeks later, Mr. Morphew still does not have proper notice of the experts, not prosecution's opinions, or all the information required by Rule 16 and Brady, Maryland, People v. District Court, and People v. Bueno. Not only does Mr. Morphew not have proper notice of their expert opinions, he does not have all the Brady discovery to which he is entitled. It is clear by the prosecution's continuing conduct of blatant disregard for court orders and Rule 16 that giving the prosecution even more time to comply with the CMO will not cause them to comply or cure the prejudice. At this point, it is apparent the prosecution's actions are intentional, including filing motions we ethically must respond to, causing the obvious consequence of taking the defense away from preparing for trial and filing motions in Lamine by today's deadline. Mr. Morphew once again moves the court to dismiss this case. Hi, Trisha Maria. Yeah, this whole case is just it's crazy. Like, just down to everything. There's just there being not that much evidence and like different thing like ways it could have went and how insane the court proceedings are. It's a circus. It's literally become a circus. Hold on. So basically, I don't know if I want to go over this, but they basically go over. They said that they did get their reports, but they were hidden in 4,000 gigabytes of data, and that they had a hard time finding it. So here we go. The prosecution. This is pretty interesting. This is the Mr. Hicks. So the prosecution motion claims that Mr. Hicks' opinions are critical because Mr. Hicks can prove what time Barry went to bed on May 9th, 2020. Mr. Hicks will testify that there is data that shows Barry Morphew was loading his truck over several hours late into the evening. Mr. Hicks' testimony is critical because it will show that Barry Morphew made 5 trash dumps in Brewfield area that next day. Mr. Hicks does not make any of this opinion in the report the prosecution refers to in their motion to reconsider. Wait, I lost my spot real quick. Sorry. In fact, the defense is unaware vehicle telematics data has the ability to identify who is doing what in or around a vehicle, and is certainly surprised an expert can identify when somebody is going to bed or whether they are throwing trash away by reviewing telematics data. Yeah, you know what, Gladys? I don't think I would not necessarily say it's the whole investigative team. I think they just were ill prepared, I guess you could say. Oh, and Gladys, I got your message, and that's totally fine. I would just say that they were ill prepared, and they did not. They should have waited. Like, I think it was too early. I really don't think they have that much, and I think that they rushed it because I don't want to get in trouble. Like, I don't know if I can say this or get in trouble for saying it. I feel like the DA wanted to make like a big show out of it, and she tried to like rush it. You know what I mean? And she like it even seemed as though she, well, I wouldn't say, but like some of the YouTubers just happened to know the arrest was coming, and Dateline just happened to be in town. I just feel like they made him. They rushed it. Yeah, they wanted to close the case, and they wanted a big profile case to make her look good, I guess, political wise. And they should have waited. And the investigators begged them to wait. They literally called the sheriff and they were like, please, we're not ready. We don't have half the reports in. Then what happens is when they don't get their reports in on time and they arrest them already and they're still waiting on things, that stuff gets delayed and they can't hand it in on time, and then everything goes wrong. So where was I? Their claims replicate the prosecution's pattern of making false claims in its pleadings in court. As far as the defense can discern from the information provided, the prosecution's proposed opinions of Mr. Hicks' opinions will contradict what is in Mr. Hicks' report. Another Doug Spence special. Mr. Morphew has still not been given, and if so, not identified, the underlying facts or data that support the prosecution's claim of Mr. Hicks' proposed opinions, and certainly has not been given sufficient meaningful information to conduct effective cross-examination. The defense would be profoundly prejudiced if the prosecution is permitted more time at this late date to provide a proper expert disclosure for Mr. Hicks. The time for hiring, consulting with, and endorsing a defense expert has passed. Mr. Morphew has asserted his right to a speedy trial and continues to do so today. So they said his report was buried in the gigabytes. They didn't hand in the CVs on time, so that doesn't make a difference anyway. So in the DA's chart, the prosecution indicates that S6303 through S6359 is the data Mr. Stevens analyzed and will be opining about regarding Barry Morphew's phone. That is incorrect. Those 56 pages do not concern Barry Morphew's phone. The pages refer to entirely different telephones investigated in the case. So basically, the prosecution is saying, like, oh, yeah, we gave them this report and that report, and that these reports are for this guy, but those reports don't even reflect what he plans to testify about. Mr. Stevens has written at least one report in discovery, and that is the report which was initially located by the defense and identified as RMR in lots of numbers. Defense referred to this 5040-page report in D62B, and the prosecution never refuted the defense belief that this report could be the report summarizing Mr. Stevens' opinions. In this report, Mr. Stevens states, I did not analyze the content of the extraction for specific data contained within the scope of the legal authority or other files that may be of interest to the case agent. It is the sole responsibility of the submitting case agent to review the provided results for relevancy and adherence to the scope of legal authority. Quote unquote, I did not analyze the content of the extraction for specific data contained within the scope of legal authority or other files that may be of interest to Agent Graham. It is the sole responsibility of the submitting case agent to review the provided results and relevancy and adhere to the scope of legal authority. Since the prosecution endorsed Mr. Stevens without an accompanying report or Bates numbers, how was the defense to know which reports the prosecution is relying upon? All right, Mr. Hicks. Mr. Hicks to Barry's phone. Let's see. His said the same thing, I guess. He didn't analyze the content. Okay, so DA motion to reconsider contains Mr. Stevens' proposed opinions, which are factually dishonest. The prosecution includes additional untrue statements in his motion to reconsider with regard to Mr. Stevens' proposed opinions in an effort to persuade the court to believe that Mr. Stevens is essential in proving that a murder occurred and Mr. Morphew was responsible for the murder. Examples, the Doug Spence specials. The prosecution represents that Mr. Stevens will testify that data that was deleted in bulk, 381 text messages, before Barry's phone was seized. The report that the prosecution points the court to has no such statement, reference, or opinion and provides no alleged time or date when this was supposedly deleted. He could not testify consistent with the prosecution's theory as stated in the motion to reconsider, as it would be false and not supported by his report. So they're trying to say, the prosecution is saying they're trying to prove through his deleted text messages that Barry's relationship with his wife had problems, because they said Mr. Morphew has always claimed that his relationship with his wife was without problems. And they said that the DA needs Mr. Stevens to refute that defense claim. This is once again the prosecution's use of an untrue statement in an effort to persuade this court to reconsider its ruling. Mr. Morphew never claimed in any of his 34 interviews with law enforcement that his marriage was without problems or was perfect. In fact, Mr. Morphew cited the spats, arguments, and verbal fights he had with Miss Morphew were what would be considered ordinary in most marriages. Let me see. I'm going to try and go through this without reading. So this guy, Hoyland, he wrote up a draft, and the report was stamped draft for lead purposes only. It wasn't an actual report, it was a draft. Well, they considered this draft to be the report, and it's not. So, like it said on the thing, that a final report will be prepared after all available data has been received and in preparation for any future trial, which they didn't do that. So how do they know that it's been updated with new available data? You know what I mean? They can't use that report or that draft as the report they were supposed to hand in. Importantly, the new 329 report contains highly exculpatory information about the times during which Suzanne's phone was being utilized. Oh, this is huge. So, they've been claiming that Suzanne went radio silent when Barry got home from work. They said, like, after 2:40 something, she went radio silent on the 9th. And that's why they believed he killed her that afternoon. Or not killed her, but tranquilized her that afternoon. Well, on the phone reports, the new phone report, it reflects that Mrs. Morphew's phone made outgoing. Who is reviewing these? What do you like? All right, so this is the defense. I got this off, I think it was Twitter. I don't know. I've been finding these little like hidden spots where people are posting them. They are getting these documents from the courthouse and posting them, and I found it now. This is the defense going over these reports and talking about them and telling the judge, the prosecution is giving us false information or whatever. So the prosecution is claiming that Suzanne went radio silent on May 9th at, 2:40 something p.m., right? And that she died on that night. And, but she didn't. According to her phone records, she made an outgoing call at 3:30 p.m. on the 9th and 7:30 p.m. on the 9th. And then she got an incoming call at 4:23 a.m. on May 10th, when the prosecution claims Miss Morphew was supposedly already dead. So that is huge because, they've really been saying that she's been radio silent, and now they got these call records, and she didn't go radio silent. There was calls, and I don't know. So in the report, I see in the report, it doesn't say who she spoke to or how long or whatever. It just says, I don't even think the defense was able to see who she spoke to or anything. So it could always, all right, Gladys, see you in a little bit. It could always have been Barry, I guess, calling someone and hanging up. I don't know. But, there was one of her friends, it said in the arrest affidavit that one of her friends claimed that they had talked to her that night. And then they wrote on like a little footnote that there was no evidence of that. But now it seems that there is. Like, why has this not been brought up? There is no identification in the report of the incoming or outgoing phone numbers from Miss Morphew's phone or the length of the calls. The prosecution has not produced the exculpatory and Brady discovery identified on the new 32922 report. So if they have that information, like who the calls were to and how long, they need to hand that over like right away. Hold on. The recent history regarding the difficulty the defense has had in its attempts to obtain the raw cell data from the prosecution is vexing and evidence of additional discovery violations. So they've been trying to get the phone data for a while, and they haven't had a lot of good luck. On March 31st, 2022 at 10:30 a.m., DA Holbert sent defense counsel an email stating that he had conferred with Commander Alex Walker and the cell data the prosecution received from Verizon exactly what was produced to the defense on the hard drive on February 1st, 2022. Mr. Holbert pointed out that the data was provided in folders E69, Barry Morphew cell data, and E75, Suzanne Morphew cell data. To begin with, this data was returned pursuant to a search warrant requesting data through May 16, 2020. However, additional data was returned by Verizon through an amended search warrant authored by Commander Walker for call detail records through June 3, 2020. Emails produced in the discovery show that Commander Walker received this additional data on June 10th pursuant to this amended search warrant. So that's kind of weird. So they got this original call data that didn't give the information. So then they got a warrant for additional call data to find out who she was talking to and how long. And the defense has never got that yet. Even though they've had it since, what do they say, June 3rd of 2020. Emails produced in the discovery show that Commander Walker received this additional data on June 10th, 2020 pursuant to the amended search warrant. Therefore, folders E69 through E75 containing data through May 13th, 2020 cannot possibly be all of the data law enforcement has received from Verizon. In addition, the data that has been produced has been altered from its original state. Some of the spreadsheets in these folders appear sorted by dates in a manner inconsistent with how Verizon produces records. That's kind of shady too. Like, why is it retyped in a different way and not how Verizon does it? As stated above, the new 2022, jeez, that's like a tongue twister, report includes newly revealed exculpatory and Brady information, but all the data supporting the old and new 3/29/2022 report has still not been produced. Whew. This is interesting too. So, Mr. Hoyland was going to testify about the airplane mode situation and how the phone showed a pattern of airplane mode around the most influential times in the case. Unlike the draft report, the new 3/29/22 report does not report on airplane mode around influential times in the case. This appears to be again a Doug Spence special where the prosecutor has or will attempt to convince its expert to change their opinion to fit the prosecution's speculative, uncorroborated theories of this case. Thank you, Grey Hat. So I think that's really important because I think what they're referring to, I think what they're meaning by the Doug Spence special is about the dog scent handler. So the dog, you know how the dog scent handler, he wrote up a report that they conveniently never asked him for. So they never asked this guy for this report, period. Didn't want the report. They find out he wrote one. They act like they never knew that he wrote one. But since they didn't know he wrote one up, they had their guy write one. And their guy just happened to write a completely different report. You know what I mean? And then the judge, if the judge had not said, listen, I want to hear what the canine handler has to say, they would have never compared the report of the officer that was there to the dog handler's report and find out they were very different. So they're trying to say is that the prosecution seems to be trying to control the narrative, I guess you could say, and they're trying to get their experts to change their opinions to fit what they want. So that's why they didn't ask the guy for the report, and that's why they wrote their own report, and they kind of got themselves caught because the judge called the guy up and they compared it. I guess that's what they're trying to say. That's what it sounds like to me. The most probable reason that Hoyland's new 3/29/22 report says nothing about airplane mode around the most influential times in the case is because Mr. Hoyland cannot make that opinion, because it would be asking him to make a false statement. The defense has learned as a result of poring over more than 20,000 pages of witness emails produced in late January of 2022 that on June 24th, 2020, Mr. Hoyland explained in an email to various law enforcement officers that the apparent airplane mode phenomenon thought to have occurred on Barry Morphew's phone was confusing. See Exhibit C. Now, in the 3/29/22 report, Mr. Hoyland, analyst for the FBI's acclaimed cellular analyst survey team, fails to make any conclusions regarding the unreliable, confusing airplane mode theory. So they had this big thing. They were going on this big airplane mode theory that he was putting his phone in airplane mode. And their expert said, hey, that doesn't make sense. I actually think I have, it might be in here. Hold on. I have a separate thing. But when they were telling him, I think it was in an email, they were talking about airplane mode. And he said that it didn't make sense. Yeah, however, the fact is that based on Mr. Hoyland's own words, the airplane mode theory is defunct. Mr. Hoyland is likely using the very raw data that defense has not been provided to draft his reports. Equally likely, he has been communicating with the prosecution team about the preparation of this new 3/29/22 report. It is hard to believe the new 3/29/22 report was created by Mr. Hoyland without a request from the prosecution, and it's hard to believe after reading the email communications between Mr. Hoyland and the prosecution team dated in June 2020 that the prosecution did not request a new report or was not made aware of its contents was not made aware of the contents of the new report. The defense has received none of these communications, even if the communications were oral. These communications should have been disclosed because they are material and exculpatory based upon the new information in the new 32922 report. Let me see if I have it. Hold on. Give me a second. Is this it? Nope, that's the outgoing calls. Hold on. Oh, alright, never mind. That was just what I'm reading. Okay. I just want to make sure I didn't. I took a piece out because that's like a part I wanted to focus on, and it's the same part. So basically, their own expert said that the airplane mode thing didn't make sense. Let me take a sip of my drink before I continue. In the motion for reconsideration, the prosecution attached Exhibit 7, a letter Ms. Dews drafted on 5/19/2021 as the document the prosecution claims is sufficient to satisfy the prosecution's expert disclosure requirements. And yes, YouTube decay, facts do matter. I think I've just always been very, I like to read the facts and, be fact-based on things, even if it's not something people don't want to hear. I just think it's important. I think a lot of this case is to blame on the prosecution. They could have done a better job, honestly. Where was I? On March 10th, the defense advised the court that it did not have a report, opinions, or basis for opinion, but had a one-page letter sent by Miss Dews regarding the CODIS matches. So I guess she didn't write a report, she just wrote a one-page letter? The court ruled this letter was not sufficient to meet the requirements of the CMO. In late January 2022, in response to the court's second order for the prosecution to produce emails between witnesses in the case, the defense received a deluge of emails written by and between Ms. Dews and other witnesses and the prosecution team. These emails reflect that the DAs convened numerous meetings with Ms. Dews and other law enforcement to discuss her CODIS opinions. To date, the prosecution has not produced Ms. Dews' opinions expressed in those meetings. Oh yeah, so they had a bunch of meetings. They didn't take notes of them. It seemed like I think there was like 2 people. I thought there was no note taken, but there was like 1 or 2 people who took notes, I believe. But hold on. The fall 2021 report includes 106 emails written between Dews and various CODIS administrators around the country. See Exhibit D, emails describing CODIS matches. Additionally, defense has still not provided the quality assurance review regarding the CODIS matches in the case. These would be exceptionally important to what the prosecution reports Ms. Dews' opinions as expressed in her 519 letter. Oh, let me talk about this real quick. Lauren Sharf did a video and she went over the CODIS matches and they were ruled out. So the first one was the Chicago one. Basically, this woman wanted to go out, and trigger warning for these stories because they're a little bit extra. If you don't want to hear it, turn your volume down for like 5 minutes. So this woman, she wanted to go out and smoke crack and go party with her friends, and she didn't come home for 2 days, and I guess had consensual sex with this guy Munchie. Well, when she went home to tell her husband what she did, because she had to explain, why she was gone for 2 days. She said that she was raped by the guy Munchie or whatever, and she made a false report. She admitted that she made a false report too. And then the ones in Tempe and Phoenix. The one, I forget which one was which, but the one, a girl was like raped on her way back from coming to, like, going to the store, or like she was at the store and it happened behind the store, something like that. And the cops ended up losing touch with her, so like they did an exam and everything, and I guess they got a CODIS profile, and then they ended up losing touch with her, and that kind of closed the case. And then the last one was a woman who was dating this guy, and I guess she was like leaving for like the army or something like that. And she told her boyfriend that she was like leaving and breaking up with him, and he got mad and retaliated by, I guess, raping her. And they got his profile and put in the system too, and the profiles didn't match. So they were able to they even took it a step further and tried to talk to that guy, and he said to talk to their lawyers or whatever. So all those things were ruled out. And then there was another one that they said there was like a Maryland hit or something, and they said that was a keyboard search, which is like, I would have to look it up again. Hold on, let me look up what a keyboard search is, and I'll explain it real quick. I wrote it down in my notebook, but I don't have my notebook. I think it's... I'll have to look it up another day and go over it, you guys, but basically it was like a false alarm. They were looking into something, and it ends up alerting the system that there could be a potential lead, even if there isn't. And it was a false alarm, basically. It's not important. But I guess you could say there's still unknown male DNA in the car, but it really could be anyone, like someone who worked on her car and they had to go in her glove box for whatever reason. So that's it. But I'm not... I read on the little note, so they had an exhibit on one of the things, in the notes, one of the person writing notes in one of the meetings, he did write that some of the profiles they found matched and some didn't. So I don't know if any matched with the profile in the car. So I think it would be more significant if they all matched, or if some of them matched, but I don't know which ones matched and which ones didn't. But it did say in the guy's notes that some of them were the same profile and some of them weren't. So let me see. The defense inaccurate confessed that the prosecution... Prosecution claims that the defense claimed their experts are lay witnesses. This is irresponsible, frivolous, and unprofessional contention. It is akin to all occasions the prosecution has made false claims in its pleading or in the court about alleged facts of the case, prior rulings, and Rule 16 requirements. The defense is merely pointing out to the court its concern that the prosecution appears to think that it can bring in expert testimony of these witnesses when they endorse them as lay witnesses in their March 4th, 2022 good faith witness list. Thus the term stealth experts. It just doesn't matter what the court rulings, facts, or the written word. The prosecution continues to prove it, will continue to disregard, misstate, mischaracterize, and create their own rules if they are not sanctioned for their misconduct. The prosecution's violations can only be regarded as willful. So they're saying that even though the judge said that they couldn't find any evidence of what they were doing as willful, they believe that it's willful. To think that this prosecution team cannot comply with court orders and behaves in this way is just negligent, is ludicrous, and is certainly willful. The prosecution motion for reconsideration only highlights his continuing contempt for court orders. It is not getting better with time, no matter the deterrent, and that is because the conduct is willful. Prosecution splice recitations of Judge Murphy's in this court's orders regarding their discovery violations and pattern discovery violations speak for themselves. A continuance will not cure this prejudice, will only give them more time to manufacture evidence based on their defunct theories. Prosecution has still not produced the mandated discovery that was utilized by the expert to opine on various matters. Prosecution is in essence begging for a continuance. This request has reverberated from the prosecution since the case was set for trial on September 17, 2021. This is because, as CBI's official testified, the arrest of Mr. Morphew was premature, was the worst decision that could be made, and there was more investigation to conduct before Mr. Morphew's arrest. Alright. That's that. Okay, so this is the ROA, which is like a layout of all the things that they have done since the beginning till trial. Let me see. So yeah, change of venue. Seal, motion for copy of sealed transcript, expanded media coverage. So I have a couple of, all right, so I have screenshots of, so the prosecution had asked to strike some of the defense's witnesses. I can't remember all of them. I know I have notes on that too, but I have to find them. But one was a doctor. He was a expert to testify on the medications that Suzanne was taking. I know they want to get him struck. And then the doctor, there was someone else and I can't remember what it was. Oh, and then they I know at one point they claimed, so they said that the prosecution was claiming that he could have shot a dart out of another gun, and then that was discounted by somebody. I'm trying to think of motion. Oh, I can go a little slower if you guys want to see it. I could probably do that too. So this like names all the motions, even ones that we haven't seen. So they wanted to exclude references of victimology, like things about Suzanne, like the medicine she was taking, stuff like that. They didn't want. Trying to see what else there is. So I have the stuff that Lauren Sharf went live and she went over today, and I took screenshots, lots of them, so I could go through them a little bit, but they're really, really all over the place because I was just taking screenshots and she had comments coming up on the screen. So some of them are like half paragraphs, some of them are whole paragraphs. So I'll do my best to read them and I guess give you the best information I can give you from what I got. Cranial taste, much motion. Where? This is so many emotions. I didn't realize there were so many. Where's the ones that are recent? Alright, should be coming up, the newer ones. Yeah, email. So Exhibit C, email from Holbert to Weiner. I believe that's the one about the gun that you can't shoot the darts out of just any gun. So this is everything the court did. So they're having a Shrek hearing for a couple of the Caitlin Rogers. She's a DNA expert. Wolfie was what was Wolfie? One was the nails. One was the dog handler. One was the materials. It's just hard to read because it's so like condensed together. All right, let me just go over the ones that I got from Lauren Sharf's thing. So bear with me. It's going to be all over the place and it's going to a little bit choppy because, yeah. So the first one, the defense wants to strike is they want to dismiss any talk of the needle sheath. Mr. Morphew requests as order excluding any testimony, photographs, or other as evidence or arguments regarding a needle sheath. The prosecution sometimes calls it a cap. Found in Mr. Morphew's dryer several days after Suzanne went missing. And other items in the arrest warrant affidavit. The one new dart book from safe in garage. I think they found one unspent one in the box and another unspent one under the bench in the garage. The DNA, they're saying that the DNA on the cap wasn't Barry's DNA. Surely the prosecution's DNA expert Rogers will not stretch the bounds of science and her ethics to conform with the prosecution's claim to testify contrary to the results obtained that Suzanne Morphew's DNA was on the needle sheath. Additionally, while the DA asserts that the DNA is relevant, if Suzanne's DNA was on the sheath, the DNA results from the body of a dart seized from the garage excluded Barry Morphew and Suzanne Morphew as contributors. Discovery page S28 135. And as for the box of new darts, the swabs from the box were not suitable for DNA comparisons as the number of contributors could not be reliably determined. Discovery page 09A blah, blah, blah. The only expert testimony offered by the prosecution to testify to this theory was a veterinarian. The prosecutor had hoped to present the testimony about the effects of an animal trank on a hypothetical deer and connect it to the needle sheath. After where was I? Sorry, it's because I took screenshots. It's like there's some more words from the old one, so I gotta find where it was because I just kept snapping. The prosecutor had hoped to present testimony about the effects of an animal tranquilizer on a hypothetical deer connected to a needle sheath. After providing the prosecution a full hearing, this court properly excluded that testimony on March 30th, 2022. Regardless of the tenacious evidence and based on the speculative theory, without any corroborative evidence, law enforcement personnel questioned Mary Morphew and perhaps others about tranquilizers, and on March 30th, 2022, Mr. Holbert stated that Mr. Morphew admitted to law enforcement about having tranquilizer serum. This is also untrue. Mr. Morphew was questioned by law enforcement about the fact that it is in the past he obtained prescriptions and then I guess used them. He obtained prescriptions and then he used them when he owned a deer farm in Indiana. And because sorry, so I had a comment on the screen, so I can't read what it is. Let me see if it's on the next page. Because cooperative evidence law person questioned Barry Morphew, perhaps others about tranquilizers. On March 30th, 22, Mr. Holbert stated that Mr. Morphew admitted about having tranquilizer serum. This is also untrue. Okay, so he utilized animal tranquilizers when he owned a deer farm in Indiana, and then because no tranquilizer serum was seized in the case, 11 months after Mrs. Morphew went missing, law enforcement provided Mr. Morphew a string of hypotheticals regarding the existence of the tranquilizers. Mr. Morphew was asked if he could possibly have any tranquilizer left from his deer farm days in Indiana. Then he was asked if he had some left. He was asked where they could have been. Then he was asked if they were on his workbench. Could he possibly inadvertently collected them with the other trash on his workbench before going to Broomfield? So basically, they're saying he never technically admitted to throwing them out. They gave him hypothetical questions and said, is it possible that you could have inadvertently thrown stuff out? And he was probably like, yeah, of course it's possible. So finally, if something had possibly happened, could he have thrown this hypothetical tranquilizer out in Broomfield? Found at the Morphew house was seized a Marlin dart rifle. Where was I? When the Morphew house was seized, a Marlin dart rifle was found in Mr. Morphew's gun safe. Now, the prosecution has been asked numerous times to provide a basis for their admission in court that a normal firearm cannot fire a dart. Only a specific dart rifle can fire a dart. This was confirmed by Undersheriff Andy Rorick at the preliminary hearing, August 23rd, 2021, day 3 of the preliminary hearing. Deputy Himshoot, who seized and photographed the Marlin dart rifle, stated that the rifle was inoperable and appeared it hadn't been used in a very long time. That was also said at the preliminary hearing on the 24th. And although the prosecution did not endorse a firearm expert, the Marlin dart rifle was recently tested. CBI firearms examiner came to the conclusion that while the rifle had the capability of firing, it could not fire in the condition it was found. The pin was broken and would need duct tape to keep the pin in place. So they're saying the court should exclude any reference to these items because the Marlin dart rifle was not operable. The prosecution has no facts regarding the alleged murder of Miss Morphew. They don't even have proof she's deceased, and no articulable theory about whether she was killed or how she was killed and how her body was disposed of without leaving a trace. On March 30th, the court denied the prosecution's request to call a veterinarian to testify about the general effects of animal tranquilizer BAM on the deer. The court stated that it was not at the time ruling one way or another on the emission of the needle sheath or cap found in the dryer of the Morphew home. The only issue before the court at the time was the veterinarian issue. The court indicated that the defense could file a motion in limine on the topic of the emission of the needle sheath at trial. On March 30th, the court made findings that are highly pertinent to this case. This court could not ignore the fact the needle sheath was found on its own at the house in the dryer drum more than a week after an entire load of wash was removed. The court did. Oh, wait, no. The court could not ignore the fact the needle sheath was found on its own at the bottom of the dryer drum more than a week after the entire load of wash was moved. The wash contained sheets and other people's clothing. It was not a situation where the sheath was found on Morphew's person, body, or even in his vehicle. There is no evidence that Suzanne Morphew was tranquilized at any time. There's no tox report. There's no spent darts found. The court did not find the needle sheath any more relevant than knives in the kitchen or a gun in the safe. The court gave Mr. Holbert the opportunity to address this issue, and all he said was it was a no-body homicide, and his response that they do not know how Miss Morphew was murdered. Under those circumstances, the court found it too speculative and that it would be an error to admit the preferred expert testimony. Under Rule 403 analysis, this court found it too tenuous and too speculative to permit the expert testimony and that it would be unduly prejudicial. The court read from the Colorado Supreme Court opinions in People v. Donald. Keep going. Holding that while inferences are permitted, they must be supported by a logical and convincing connection between the facts established and the conclusion inferred. And B, by guessing, speculation, and conjecture of a mere modicum of relevant evidence. Whenever Mr. Morphew objects to evidence, testimony, and information, regardless of whether the objection is made in a pretrial motion or a trial, he is also objecting arguments, remarks, and prosecutors' questions and all other comments on that topic. He requests the court prohibit the prosecution from making any statements, arguments, remarks, or any comment on the topic or including in any situation. So basically, they don't want to talk about the needle sheath at all. They also asked that they not talk about the other contents in the dryer, like the sheets and the pair of Barry shorts. They asked that they not talk about the unfired and untested .22 caliber cartridge found on the master bedroom floor. They asked that they not talk about a picture frame and surrounding area covered in a brown color substance yielding negative results for blood. They asked that they not talk about a stain on the garage area yielding negative results for blood. Another stain in the exterior driveway between second and third garage doors yielding negative results for blood. A stain yellows in color by the master bed yielding negative results for blood. A book titled A Courage to Change, which I believe is Suzanne's AA book. Various journals found in the home. A yellow-handed boning knife in the garage. It was found to have non-human blood on the handle and unidentifiable DNA on the blade. The court should prohibit not only direct evidence, but any indirect evidence, questions, and comments by others, including Mr. Morphew when he was questioned. Collectively, this will be referred to as the evidence. The objection, though, includes any and all prosecution. What cut off there? Prosecution colloquially statements, questions, or arguments about it, not simply evidence or testimony sought to be admitted. Sorry, I need a drink. Okay, 1 second. Such evidence is irrelevant because there is no proof that it is connected to Suzanne's disappearance. Prosecution has no facts regarding the alleged murder of Miss Morphew. They don't even have proof she is deceased, no articulable theory about whether she was killed, how she was killed, and how her body was disposed of without leaving a trace. To the extent the prosecution might be hoping that jurors infer that Mr. Morphew has a bad character because of any of this evidence, it is also inadmissible because it is bad character evidence for which the prosecution gave no notice as required by CRE 404B3. Give me a second. These items are not relevant. Omission would create a substantial risk of unfair prejudice that will overwhelm any marginal probative value under CRE 403. Depending upon the prosecution's purpose, some may constitute character evidence, which is explicitly precluded by CRE 404B. Mr. Murphy will not argue each of the items because it is patently obvious why they should be excluded. However, a few examples are illustrative. Numerous irrelevant DNA swabs taken and tested. Caitlin Rogers' reports contained dozens of items that were tested for blood and DNA, yielding no relevant results whatsoever. It would take a very substantial amount of time at trial to go through every single item that was tested. Rogers' testimony should be limited to items of evidentiary value and not include the universe of every single irrelevant item tested. The dryer contents, including a pair of Barry's shorts. While issuing its ruling excluding the testimony of the prosecution's purpose, some may constitute character evidence which is explicitly precluded. Mr. Morphew will... Oh, wait. Sorry, I'm in the wrong one. While issuing its ruling excluding the testimony of the prosecution's proposed veterinary witness, the court pointed out that the needle sheath or cap found in the dryer of the Morphew home was not probative because, among other reasons, it was found in an entire load of wash, including other people's clothes and sheets. The fact there were sheets and other clothes in the dryer is irrelevant. The unused cartridge on the bedroom floor. Oh, they also said about his sheets, or the sheets and the shorts. They were trying to say that the shorts were the ones he was wearing that day, but apparently Barry had lots of khaki shorts, many pairs that look similar to the pair he was wearing that day. He had some in his truck, he had some in the house, he had a pair in the dryer. They were all very similar, so it was kind of hard to say they were the ones he was wearing that day, the ones in the dryer, and that's where the cap came out of. The cartridge found on the bedroom floor. It is one of many bullets found in the house. No significance other than to show Barry and Suzanne Morphew owned guns and ammunition, and Barry was a hunter. There is no DNA testing of this cartridge. He filed a motion asking that they exclude testimony about it. A book titled A Courage to Change at the preliminary hearing, Under Sheriff Andy Rorick testified that Suzanne's Al-Anon book, Courage to Change, was found on a couch in the sitting room next to a Bible. Based on double or triple hearsay, Rorick testified he expected to find Suzanne's personal journal near those items, but did not. The book is irrelevant to any material issue in the case. It is also irrelevant whether Rorick found Suzanne's personal journal or not. Omission of these items simply invites speculation and conjecture. The court should exclude these irrelevant items. The motion in Lamine is required to prevent mention of information and information derived from remarks or questions to prospective jurors in the prosecution's opening statement. The damage will be done long before the prosecution even calls the witnesses to the stand. Alright, yeah. So basically they're just asking not to include these things because they don't feel they're of relevance, and they feel like the jury could, make inferences on them when they shouldn't. Like, just because they said her journal should have been there, it doesn't really make a difference either way. So the next one is motion to exclude clothing and material found in the community dumpster. So basically, in the dumpster outside of Barry's house, they found some camouflage clothing, a router, and some beer bottles. The court should prohibit not only direct evidence, but any indirect evidence, questions, and comments by others, including Mr. Morphew when questioned. This is a continuing objection based on constitutions. Mr. Morphew also seeks out order that the prosecution shall formally admonish its witnesses to not comment on the subject. So the dumpster, in support, Mr. Morphew states, the dumpster is utilized by the entire community, which means there's probably all kinds of DNA getting mixed around in there. Law enforcement found nothing of relevance to this case in the dumpster. There was apparently some other person's camouflage clothing found in the dumpsters. The clothing did not have any of Barry Morphew's DNA, hairs, or other identifying physical evidence on it. A router and other objects, including glass beer bottles, were found in the dumpster. The router was not connected to the Morphew home. The beer bottles have Mr. Morphew's DNA on them, but there is nothing relevant about Mr. Morphew drinking beer at some point prior to being in the dumpster being irrelevant to this case. Such evidence is irrelevant because there's no proof that it's connected to Suzanne's disappearance. Prosecution has no facts regarding the alleged murder of Miss Morphew. To the extent the prosecution might be hoping that jurors infer that Mr. Morphew has bad character because he owned camouflage clothing or threw it away. This is bad character evidence for which the prosecution gave no notice as required by CRE 404B3. So the next one is a motion to exclude conversation about immunity. So Barry had some conversations with law enforcement about asking if he could have immunity on March 5th, 2021, approximately Barry's 30th interview. He voluntarily submitted with law enforcement. He mentions immunity. The following exchange occurred. Barry says, "What about the immunity? Can you give me immunity if I sit and just open my life to you?" And then they said, "Who would you like immunity from?" And he said, "I think in case somebody falsely accuses me of something." And then Ellie says, "You won't be falsely accused." And he said, "It happens all the time." So, and then they said, "Barry, there's nothing that you..." I can't read that last word. Let me see if I have a clearer picture of it. Okay. "There's nothing that you can..." Then Barry says, "You guys, they got guys coming out of jail from DNA all the time." And they said, "Barry, for us to put you in jail for something you didn't do..." Doesn't get us any closer to finding out what happened. And then you've mentioned immunity, and we thought about it a little bit, and if we could structure some kind of setting to make you comfortable to talk, we are happy to do that. Then Barry said, "That's the only thing I'm worried about. I don't have anything to hide. I have been talking since day one, and everybody that knows anything had told me, dude, you need to shut your mouth." Which he should have done. After this exchange, Mr. Morphew spoke with law enforcement on 4 more occasions. This entire exchange is irrelevant to material issues in the case. Introducing this part of the conversation, especially out of context, to the entire interview, out of context to the entire interviews up to that point, would amount to speculative character and propensity evidence. It is excludable because it is not relevant under CRE 401 and carries substantial risk of unfair prejudice that would overwhelm any marginal probative value under CRE 403. The next one is to exclude evidence and testimony about digital forensics. They basically are asking to exclude any testimony, photographs, or other evidence regarding digital forensics. When we use the term digital forensics, he means to include computer telematic forensics, digital data extraction from a computer, iPad, vehicle, or any other digital device, cell phone location or cell tower telematics from vehicles or any other device, and use or development of forensic software. Forensic devices, extract analysis, digital media, blah, blah. So basically, they're asking to exclude digital forensics, and they're asking to exclude it because their expert can only testify as a lay witness, and a lay witness cannot explain digital forensics. So they're asking that it just be completely not be able to talk about it. In support, Mr. Morphew states that prosecution does not have any endorsed expert in digital forensics. The prosecution did not endorse any expert in digital forensics. Digital forensics testimony and or evidence cannot be admitted through a lay witness, but requires a person qualified by specialized knowledge, experience, and training in the field of expertise. Colorado Supreme Court has ruled that when an officer's testimony is based not only on her perceptions and observations at the crime scene, but also on her specialized training or education, she must be properly qualified as an expert before offering testimony that amounts. I didn't hear the rest of that. I didn't get that screenshot. So basically, in a nutshell, they're asking that it be taken out because they don't have an expert witness to talk about, which is typical to take, I guess, to try and take advantage of it. It sucks for the prosecution, but I'm not surprised that they're doing this. Without an expert testifying to the identification, retrieval, analysis of deleted files found in the reports created by Protect, Doro has not presented evidence where the underlying facts are admissible at trial. Not only would expert testimony be required, but this is based off another case. Mr. Hennig could not testify to the report's context for the truth of the matter they assert against. So they're using other cases to prove. At the preliminary hearing, even the prosecution objected that testimony about airplane mode on Barry's phone would require an expert witness. Mr. Lindsay, Judge, I'm going to object to defense questions about airplane mode on Barry's phone. That's speculation. I don't think this witness is actually capable of answering that question. So, I guess at the time of the hearing, they had somebody up who wasn't an expert, and Lindsay objected and said that he wouldn't be able to testify to the airplane mode. So now they're using that against him and saying, oh, well, you did this in the preliminary hearings and said that that person doesn't have the expertise to explain it. So how could a non-expert explain it in court now? Preliminary hearing testimony of Detective Grusing demonstrate that the prosecution will need an expert witness to introduce text messages. Law enforcement was not engaged in the mere retrieval of text messages. Rather, expert extraction analysis were required. As one example, at the preliminary hearing, defense counsel followed up with Detective Grusing about May 6 text he believed was from Suzanne to Barry that started with "I'm done." When the defense counsel asked if it was found just right there on Barry's phone, Grusing explained it was more complicated than that. No, they had to really diagnose his phone to find it. I believe it was a resident image that was hidden. When an expert has a phone to find a resident image that was hidden in the testimony. When an expert has to diagnose a phone to find a resident image that was hidden, a testimony must come from an expert. Sorry, I'm trying to puzzle piece the words together that are blocked out from the comments underneath. So, yeah, in a nutshell, they're trying to get rid of that. The next one. Oh, they're also okay. So the next one, they're also trying to get rid of like the telematics too, or they're still talking about the phone pings actually. So they're talking about how the phone pings, if the pings were correct, the phone would be traveling through the walls of the house, and quite a bit faster if the phone was going through walls. 53.6 feet per second between points 1 and 2. Grusin constantly stated that he did not understand the calculations or data and that it would take an expert to do so. As for the allegations about Barry moving around his house on May 10th, an email provided to the defense in January 2022 reveals that law enforcement has always known that its computer science data about movement on the date is seriously flawed and cannot be relied upon. See Exhibit A to this motion, a 6/2/2020 email from Hoyland to other investigators. As an FYI, one of the challenges is determining movement with GPS readings in a tight area is that there is a phenomenon known as static drift, whereas a stationary device can be mistakenly shown to be moving because of the number of satellites taking measurements in their corresponding locations to the stationary device. See, I know exactly what they're talking about. So me and my husband, we have like Find our iPhone on our phones, and like occasionally when I open it and see where he is. So he used to work at his job, which was next to the river, and a couple times I've checked it, and it's literally placed him in the middle of the river, like his little pig. And obviously, he's not swimming in the middle of the river for his phone to ping him there. But there's been times that I looked at his phone that it would place him at like, I guess like a place he was driving by. So it would look like a house on a street. And then after a second, it would update to like where he was. But I wouldn't even wait a second and be like, what the heck is he doing at this person's house? I'm going to kill him. To call him and start flipping out on him. And he's like, what are you talking about? And then I go and look and it's like, he's at this place way farther away. It was like never there. But it does this weird thing where it like, if you're in a tight area, it'll make you look like you're in a river nearby or if you're walking around. So I get what they're talking about there, and I think that could have been static drip as well. In the email, they're talking about what is in the email. The guy said, quote unquote, as an FYI, one of the challenges in determining movement with GPS readings in such a tight area is that there is a phenomenon known as static drift, wherein a stationary device can mistakenly be shown to be moving because of the number of satellites taking measurements and their corresponding locations to the stationary device. Or it could be him walking around the property. Just hard to say, but I would be cautious in jumping right to the conclusion that he was bouncing around his property at these hours. So the guy and then they show a picture of the email of the guy basically saying that. I could send it and show it, I guess. Hold on. That's already in my Facebook. Let me see if I can pull it over. Give me 1 second. There we go. I'll show you guys the email. Sorry, my throat is like really dry. There we go. New window. Got it. Alright, so it's kind of hard to see. I don't think I can zoom in, but if you look there, that's the email. I don't know how I could zoom in, but it basically says what I just read about the static drip and all that jazz. Okay. You know what? I'm not reading this stuff. I'll put my picture of my cute lizard up in the background. All right. So the next one So they want to dismiss the telematics. Next one is they want to dismiss statements about their marriage, or statements made about them, including and not limited to Holly and Jeff Wilson, Sheila Oliver and her husband Darren, Marvin and Jean Ritter, and others. This motion includes statement that Sheila Oliver captured between herself, Darren Oliver, and Mr. Morphew during her, I don't even know how to say this, serendipitous. I think that's what it says. Recordings of their conversation, statements that Mr. Morphew made to Holly and Jeff Wilson after Miss Morphew disappeared which were surreptitiously taped as FBI and CHS confidential human source. So basically, they were confidentially recording Barry. The motion includes statement that Sheila. Oh wait, no, I said that. Hold on. Martin and Jean Ritter comments based upon their pseudo-human detection expertise regarding Mr. Morphew's behavior after Mrs. Morphew disappeared, and false accusation that Mr. Morphew touched Miss Wilson's breast inappropriately while hugging her goodbye. Additionally, Suzanne Morphew's estranged family, collectively referred to as the Mormon family, have engaged in publicizing their beliefs about Mr. Morphew's conduct in statements on shows such as Dr. Phil, Profiling Evil, Nancy Grace, and 48 Hours. This motion includes testimony about others who personally interpret Mr. Morphew's mood, demeanor, or effect to be that Mr. Morphew has suspicious effect or that he seems to be guilty. This motion also includes a request to exclude the ridiculous accusation by Miss Wilson that as she and Barry were parting, he touched or attempted to touch her breast while they were hugging goodbye. Mr. Morphew also seeks an order that the prosecution shall permanently admonish its witnesses to not comment on these opinions or subject. The prosecution has previously disclosed some 6 hours of surreptitiously recorded tape recordings of conversation Barry had with Holly Wilson, her husband Jeff Wilson, Sheila Oliver, and her husband Darren Oliver. These 4 individuals were involved in making numerous pointless attempts to obtain incriminating statements from Mr. Morphew. Mr. Morphew did not make incriminating statements. There is no confession, no admission against interest, no smoking gun, no probative evidence that he had anything to do with Suzanne's disappearance. The recorded interviews are lengthy, confusing, muffled, and hard to hear. At one point, the tape recordings even pick up the sounds of what appears to be Jeff Wilson urinating. Apparently, her husband wore the FBI installed wire, and the wire recorded him walking to and urinating in the bathroom. There are literally hours of irrelevant material. Sometimes Mr. Morphew and Miss Wilson can be heard speculating that Miss Morphew may be gone for good, while other times one or both of them is holding out hope she may be found. They discuss what Barry will do now, whether he will move away or stay, what their daughters might do. Their lengthy speculation, musings, and back and forth about what might happen are fully understandable only in the context of the entire discussion. If the prosecution plays any part of the recordings or asks Holly Wilson or Sheila Oliver or their husbands about them, it will force Mr. Morphew to insist the prosecution play much of the rest of them to avoid the jury being left with misleading, out of context snippets. So basically, they want them to play the whole thing if they bring that up, because some of the stuff, they don't want them to take pieces out so it doesn't get out of context. Sorry, I'm just going through this to pick out what's... Morphew is not on trial for having a good or bad marriage. That proposition does not tend to prove Suzanne Morphew is dead, that someone killed her, and that it must have been Barry. It is a huge distraction. that will take up days of testimony only to confuse and mislead the jury. Any slight probative value is substantially outweighed by the danger of unfair prejudice. There will also be inherent prejudice in this area. Mr. Morphew's attorneys having to constantly be objecting, and the jury wondering what Mr. Morphew's lawyers are trying to hide, when they will merely be seeking to exclude irrelevant cumulative evidence. Alright, so the next one is motion to exclude testimony that Barry had the capacity or personality traits to commit murder, or that Suzanne Morphew did not have the capacity or personality traits to commit suicide or leave her family. Colorado's rules of evidence set forth with specificity what kind of opinion and reputation testimony may be testified to a trial. The credibility of a witness may be attacked or supported by evidence in the form of opinion, not reputation, but subject to these limitations. Character evidence is excludable because it is not relevant under CRE 401 and carries substantial risk of unfair prejudice that would overwhelm any marginal probative value under CRE 403. Character evidence is explicitly precluded by CRE 404B. Witnesses endured by the prosecution must be admonished prior to trial to avoid testifying to improper character evidence. And testimony should not be elicited from witnesses. That type of evidence would include, but not limited to, remarks or belief that Mr. Morphew is capable of killing Miss Morphew, that he is weird, controlling, jealous, makes him nervous, never liked him, or that he is angry, explosive, or quick-tempered person. It would be merely an attempt to portray Mr. Morphew as a bad husband, insinuate that he had a past inflicted psychological or physical abuse among Miss Morphew, all to suggest that he acted in conformity therewith. Similarly, witnesses should be admonished that they may not give personal opinions that they were afraid for Miss Morphew's safety, such as, after the fact, personal opinions are irrelevant and essentially propensity evidence. Any slight probative value is substantially outweighed by the danger of unfair prejudice. Alright, the next one is to exclude the use of the term no body homicide. They're saying that no body homicide is neither a medical or legal term. It is not a murder case in which the medical examiner has declared a cause of death. Indeed, there's no death certificate. Thus, in the case, the prosecution must prove both that the person is deceased and must be proved and a homicide. Neither one of these propositions is self-evident and must be proven by a reasonable doubt. To use the term no body homicide carries a substantial risk of unfair prejudice, and inhibition will cause an unfair trial in violation of due process clauses. I can't read the rest of that. Using the term no body homicide to describe the charges in this case amounts to characterizing the allegations as a certain type. The only reason to do it is to get through the back door when it is impermissible through the front door. As the court made clear, bringing this profiling and victimology testimony in under the guise of something different would be unfair. They also don't want testimony about whether the defendant was offered a polygraph or willing to take one because it's not admissible. So they want that gone too. They're saying that lie detector tests do not have enough reliability to justify the omission of expert testimony based on their results. If therefore follows that a suspect's willingness or unwillingness to take such a test is likewise without enough probative value to justify its admission. The suspect may refuse to take the test, and because he fears that it will reveal consciousness of guilt. So basically, he didn't want to take the test, and they can't hold it against him because it's not admissible in court anyway. They're saying that they shouldn't be able to talk about it. And there's a few more. I'm not gonna read all of it because it's just taking forever, but I will tell you what's left. So they want the telematics. They also want the telematics taken away, like the truck telematics, for the same reasons that that there's no expert to testify in the telematics. I'm just flying through this. And then they're trying to get rid of evidence, testimony, arguments, and comments about Mr. Morphew's hunting and firearm skills. So basically saying, because he likes hunting, it shouldn't be used against him. Like, using hunting as a way to make him look like a murderer. It's like using the fact that somebody likes ice cream against them. He enjoys hunting. He has hunted numerous types of animals in his life, including elk, deer, moose, and even chipmunks. Such evidence is irrelevant to the case other than to paint Mr. Morphew as a person who kills animals and shoots guns. Such character evidence invites jurors to speculate. Barry Morphew. And the arrest affidavit. So this is actually said quite brazenly in the arrest affidavit to attest Mr. Morphew. Barry Morphew resorted to hunting, or resorted to something he has done his entire life, hunt and control Suzanne like he had hunted and killed those animals. So basically, they were alluding in the arrest affidavit that because Barry was a hunter, he hunted and controlled Suzanne like he had hunted and killed animals his entire life. So they're saying, they'll take those words and make them look bad, For a time, the prosecution made much of a theory that the fact Barry has chipmunks that the fact that Barry has shot chipmunks is evidence of guilt. In the arrest warrant affidavit at the preliminary hearing, law enforcement espoused the belief that computer science proves that Mr. Morphew was moving a lot around the outside of his home as if he was chasing Miss Morphew on May 9th. In the arrest affidavit preliminary hearing, chasing him as if he was chasing Miss Morphew on May 9th, reliable, and that it was reliable evidence that occurred. And the emails from a computer science data expert indicates the data extracted from the cell towers does not support this theory. So they're saying basically the pings that they had does not support the theory that he was chasing Suzanne and that it could have been static drip. Let's see what else. They say a lot more stuff, but it would take me a really long time to go through it. But all evidence that Barry Morphew hunted or killed animals of any type is inadmissible. It is speculative character and propensity evidence. It is excludable because it is not relevant and carries substantial risk of unfair prejudice that would overwhelm the marginal probative value under CRE 403. Hold on. Prosecution has no alleged murder weapon. They have no evidence of Miss Morphew was allegedly killed. Indeed, they have no evidence that she is dead or that any firearm was used in connection with her disappearance or death. They certainly have no evidence that Barry was chasing Suzanne around the house trying to kill her on May 9th and that he something had said he was chasing chipmunks and trying to kill them. Example of evidence that motion seeks out to exclude. Oh, so they don't want a push pin map to be. So I don't know if you guys saw the evidence that they released on the actual website, but there was a picture of a map with push pins in it. And on the push pins, there was like different things that they could include it or whatever. They don't want that push pin map to be shared, because it would create like speculation that those things happened in those areas when it actually didn't. Here it is. At the preliminary hearing in the arrest warrant affidavit, a map was referred to as the pushpin map. Mr. Morphew referred to it as the pushpin map in this motion. However, the motion is broader than simply this one exhibit. This exhibit and the testimony surrounding it purports to pinpoint exactly the precise locations at Morphew home and a particular cell phone was located at any given time at day or night. Upon information and belief, the prosecutors... Oh, that's okay, Queen. I know, I'm getting hungry. I gotta go get some dinner, too. Where was I? Cell phone location testimony and evidence can be admitted through a lay... Or cell phone and testimony cannot be admitted through a lay witness. So they're also saying that these pushpin maps or whatever cannot be permitted through a lay witness, and they don't have an expert, so they can't do that either. And then computer data. We're talking about static drift again. All right. So then they have another one where they want to restrict the prosecution's comments, questions, arguments, and statements. So things like Linda Stanley brought up this puzzle analogy, saying that that circumstantial evidence is like a puzzle, an incomplete puzzle, and you have to put... Oh yeah, when the DA was on YouTube discussing the case. Well, so here's the thing. She was careful about what she said. Like, she didn't really give a lot of details of the case, but what still was wrong about it is that the YouTube channel is called Profiling Evil. So when people watch it, they're going to assume that Barry's evil and that they're profiling. You know what I mean? Like, even the name of the channel can cause or taint a jury and make people think that he's a bad person when there's no evidence to suggest that he is. So, like, they're as of right now, if the judge doesn't like let them have some of their witnesses back, I think that they're going to withdraw. I mean, they should if they don't get their witnesses back, because they will literally have no case, because the lay witnesses cannot talk about telematics. They can't talk about phone pings. They can't talk about DNA. And that's like the main points of this case and the main things they need to use. So if they're not allowed to talk about it, then that blows the case for them. So what would be in their best interest is to withdraw before the jury gets... because as soon as the jury sits down, like as soon as the jury takes a seat, double jeopardy double jeopardy clause starts right away. So like, if I was Barry's lawyers, I'd be like, let's go. Like, it's like, stop worrying about what jury we're picking, just get them seated, because if they don't have these witnesses, they really can't testify to anything anyway. Just have these people sit down and let's go. Because if he's not guilty, if he's found not guilty, they can't retry him for the same crime later on, because that's double jeopardy. So they would have to withdraw before the jury gets seated, and then if they withdraw, they can come back and charge him at a later time if they find more evidence, which I think would be the best route for them to go. So they're also asking that, like, besides the puzzle analogy, they don't want like fill in the blank arguments, or what is it when you the prosecution should be admonished to make no comment on the okay, so if the defendant doesn't want to testify or if he wants to remain silent, they shouldn't be allowed to make any comments on that. Comment on refusal to testify is remnant of inquisitorial system of criminal justice, so they can't comment on if he's going to testify or not. Withholding consent to search, nervousness when asked for consent. Although the defense is not aware of Mr. Morphew ever withholding consent to search, the prosecution may claim he was nervous when he consented. This reasoning is equally applicable to use of a defendant's refusal to consent to entry or search. So, yeah, they could technically say, like, even though he let them search the house, he was nervous, which would make it look bad to a jury, so they're asking that he not do that either. The court should admonish the prosecution to refrain from stating or implying the victim's rights are equal or greater to those of the criminal defendants, that victims are entitled to due process or similar comments. People's right to a fair trial or both sides' right to a fair trial. The same principle requires the court to admonish the prosecution to refrain from stating or implying that the people have a right to a fair trial or any similar concept. The Bill of Rights of the U.S. Constitution in Article 2 of the Colorado Constitution protect the individual against the government, not the other way around. Putting on a defense is tantamount to minimizing, denying, or blaming others. This court should admonish the prosecutor to refrain from stating or implying that when the defendant puts on a defense, he is denying or blaming others or minimizing and juxtaposing this argument against the jury instructions that will be given in the case. This type of argument has arisen in cases where the prosecutor puts the jury instructions on a PowerPoint and then emblazons in red lettering across the instruction blame, deny, and minimize. The presumption of innocence, although not articulated in the Constitution, is a basic component of a fair trial under a system of criminal justice. Faulting the defense for not investigating more, calling witnesses, conducting scientific testing, or taking other steps to prove his innocence. So they can't fault. They're asking that they can't fault the defense for anything they did in his defense. And then I have a list of all the evidence that they have included. Oh, also, I forgot these. Calling Mr. Morphew names or pointing at him, saying Mr. Morphew or any other witness was lying. Denigrating the defense by labeling the theory of defense or calling it ridiculous or absurd. Golden rule arguments, putting the jurors or community in Suzanne. They can't ask to put the jurors or community in Suzanne Morphew's shoes or seeing the evidence through her eyes. Well, they're asking that they can't do that. I doubt all this stuff will be given to the defense because I feel like if it would just be a whole lot of objections the whole time. Like everything they say to be like object, because it's hard not to do that stuff in a case. So I just don't feel like it will all be granted, but we'll see. There's also like a big list of evidence, like firearm photos, Foosa's Lake photos, map of Garfield Mine. They're going to show a map of Garfield Mine. I'm not sure why. Morphew interviews, photos of Barry's new residence, teal clothing pics, folder labeled AK. I wonder if that's about the YouTuber AK. Folder labeled Alice Jensen, folder labeled Andrea Gilmore, folder labeled Eddie claims spies in group, screenshots, photos, audio interviews with DSI employees. There's going to be a recorded call with Barbara Rush, recorded field contact with Barry Morphew, a whole bunch of investigator cabinet files, Justin Krabari, Rocky Mazza, Lisa Wood, Walmart, 49, I guess, pen recording, audio clips, interviews, Dispatch recordings, CBI, Tyson, Salida. Let's see. Trail cam. Lots of trail cam video. Andy Mormon interview, Chris Mormon interview, Holly Wilson interview, Andrew Mormon, telephone call with Andrew. There's more trail cam video. Interview with Kevin and Suzette Magyar. I don't know who some of these people are. I don't remember hearing a lot of these names. Message received from Chris Mormon, Kurt Saylor. Oh, Kurt Sigler's their friend. Is that that's the guy from? Is that the guy from Arizona? Hey, Nut Milk Stand. It feels so funny every time I say it. The Nut Milk Stand. Interview with Cassidy Cordova. Andrew Mormon interview. Janelle Nipple interview. I think isn't Kurt the guy that Barry thought Suzanne was having an affair with? Could be totally wrong with that, but I feel like I recognize his name with that. Kurt Sigler phone call. I guess they have video from a grocery store, Walmart surveillance, Draper video files, game cam thumb drive, cellular wine and spirits, A1 auto. This is all CCTV footage, it sounds like. They have A1 auto. What else is there? Salida Auto Sales, Rocky Mountain Home Health. Maybe these are just all places he drove by or was near. Kanoko, that's like the gas station. Ace Hardware, 3D Cannabis, Great Western Hotel, Soulcraft, Wind Supply, Rainbow Car Wash, Big O Tires, Salida, Collegiate Peaks Bank, Monarch Crest, Shell Station. Like, what are they going to do with all these videos? Safeway, Surf Hotel, Antlers Hotel, Sunrise Solution, Chimney Doctors, Park County Sheriff Bailey Substation, Holiday Inn, National Park Service, Thumb Drive Spy Pen, Barry's iPhone, something tracker data. I wonder if they're tracking them. Said RAB tracker data. iPod 4G working copy, iOS full system, RMR CFL results. Voicemail detail from Verizon, Barry's Bobcat, GPS records, Tower Dump records, Barry's Bobcat, Verizon SIM records. Barry T-Mobile return, Barry's Verizon CDRs from January, George Davis phone records. Wow, they got a lot of phone records. They got Libbler phone records, Morgan Gentile phone records. Shoshana phone records, Suzanne phone records, Barry's skid steer record, GPS records for Barry's skid steer. They got where did I leave off? Cody Cox phone dump, George Davis, no subscriber info from Verizon, Morgan Gentile, amended Verizon records. Suzanne Verizon, more amended Verizon records. I think these are the records that the ones that are in more detail. Verizon records for Miles Harvey, Macy Morphew, Mallory Morphew, Suzanne Voxer account returns. Then they have one that says phone data and it's blacked out. I don't know what that means. It says phone data, phone data, phone data. It's all blacked out. Macy's iPhone, Mallory's iPhone, Suzanne Apple decrypted. The Snapchat records, Suzanne Snapchat, Barry Morphew Facebook, Barry Morphew Google, Jeff Smith Facebook records. I wonder if that's one of the guys that Suzanne requested. Macy Morphew Facebook, Macy Morphew Google, Mallory Facebook, Miles Harvey Facebook records, Miles Harvey Google information, Morgan Gentile Facebook records. Damn, they got a lot of stuff. Suzanne and Mary's Dropbox, returns and emails. Suzanne first urgent Facebook request. Suzanne second amended Facebook records, another second urgent Facebook request. Suzanne WhatsApp PDF. Ooh, that would be interesting. Barry's Instagram. Suzanne's urgent return. Macy, Mallory Instagram, Miles Instagram, Snapchat records for all the people I named, Twitter records for all the people I named, Morgan, Gentile, Google, Huntington National Bank records, Fidelity returns, Monex returns, Suzanne Venmo, jail calls, FBI discovery, and that's it. It's a lot of stuff. Alright, well, that's all the stuff I got for now. I know there is stuff that the prosecution filed against the defense that I don't have on me right now. I know the one is things about her. They don't want to include things about Suzanne's character. Like, I guess they don't want to paint her in a bad light as like somebody who would like run away from her kids, or that she was taking medications or could have committed suicide, stuff like that. And then they wanted the doctor excluded that was going to talk about her medications and the side effects of them, and I guess if she was capable of committing suicide, things like that. I will get a hold of that, and maybe next update video I'll do it. On the 19th, they're having a pre-trial hearing, so it's in 3 days, and then and then they're going to start selecting a jury on the 28th, which is in 12 days, and then I have another Shrek hearing about witnesses, 13 days, and then it's go time. So if anybody hasn't been caught up or like doesn't know the backstory, I did a little in the beginning of the live. I did a little refresher, but I have done videos where I talked about it in a lot more depth. So if you want to go back and check them out. But I'm going to get off because I have been on here for 2 hours and 30 minutes writing court documents, so my eyes hurt. And I worked all day, so I just came right home and did this. But I will definitely keep everyone updated on the case updates, and hope you all enjoyed it. And happy Easter, everyone. I hope you liked the picture of my cute little beardy dressed as the Easter Bunny. Thank you for coming. Love you all. Good night. Bye.